Number 10, David
Number
Clendon.
10, indeed.
My apologies, my eyes are...
Mr. Speaker, my question to the Minister of Energy and Resources. Does the Minister agree with Crown Minerals' testimony to the Waitangi Tribunal's inquiry into the management of the petroleum resource, which confirmed that the Crown has an obligation under both international law and the Treaty of Waitangi to investigate claims of customary rights?
Mr. Speaker, I understand that the comments referred to by the Minister came at the end of a very long cross-examination in front of the Treaty of Waitangi Commission, and I don't want to make any comment on that matter at all, but what I do want to say is that the New Zealand government is a sovereign coastal state and is therefore the only legal person that has any right to explore and exploit, conserve, manage natural resources on the continental shelf as recognised by the United Nations Convention on the Law of the Sea and ratified in the Continental Shelf Act 1964. Mr. Speaker, I would suggest that if the member wants to argue that the United Nations has got it wrong, he needs to take that argument to a different forum. He may also like to consult with his colleague, Dr. Kennedy Graham, who is an expert on the effect that United Nations declarations such as this can have.
Supplementary.
David Clendon.
Does the Minister agree with Crown Minerals' testimony that the ownership of oil in the exclusive economic zone is, quote, a live issue?
The Honourable Jerry Brownlee.
No, Mr. Speaker, I don't. Section 10 of the Crown Minerals Act reserves all petroleum, including that in the foreshore and seabed and the outer limits of the territorial sea. Mr. Speaker, Section 3 of the Continental Shelf Act refers back to the UNCOAL declaration I spoke of before and makes it clear that all rights that are exercisable by New Zealand with respect to the continental shelf and its natural resources for the purposes of exploring the shelf and exploiting those resources are vested in the Crown.
Rahui Katane.
Thank you, Mr. Speaker. Is he aware that in its 2003 report, the Waitangi Tribunal found that the expropriation of the pre-existing Māori rights to petroleum arose from a context riddled with breaches of the treaty? And what will he do to assure iwi that further breaches will not be created either through his actions or that of Crown Minerals?
The Honourable Jerry Brownlee.
Mr. Speaker, firstly, there is no intention to overturn the 1937 Act that nationalised the particular minerals the member mentions. As for ongoing participation, I have given in written form my commitment to in verbal form to the aggrieved parties in the most recent case that we would do better in the future.
David Clendon.
Does the Minister agree with Crown Minerals' testimony to the Waitangi Tribunal that the Crown does not own the oil in our exclusive economic zone?
The Honourable Jerry Brownlee.
No, and I refer the member to the answer I gave just a few minutes ago.
David Garrett.
Thank you, Mr. Speaker. Supplementary to the Minister. How can he possibly disagree with the contention that the Crown has an obligation under international law to investigate Maori claims to petroleum when he is part of a government that has signed up to the United Nations declarations on the rights of Indigenous peoples?
The Honourable Jerry Brownlee.
Quite simply because I don't entangle the requirements of both declarations.
David Clendon.
Is the Minister saying that Crown Minerals was wrong when they said that the Crown does not own the oil in our exclusive economic zone?
The Honourable Jerry Brownlee.
Mr. Speaker, the questioner asks me to accept the proposition he sets out in his primary question is agreed by me. I made the point that I would not make a comment on that, and I won't now.
David Garrett.
To the Minister, can he rule out granting compensation to iwi for confiscation of petroleum resources as required by Articles 10, 26 and 32 of the United Nations Declaration on the Rights of Indigenous Peoples? And if not, why not?
The Honourable Jerry Brownlee.
Well, quite apart from the fact that domestic law takes precedence over United Nations law, although the United Nations declarations clearly can give credence to domestic law, I'm afraid I'm not able to bind any future government.
David Clendon.
Does the Minister believe he acted appropriately when he disregarded a claim raised by Te Aupuri iwi about ownership of oil off the Rianga coast?
The Honourable Jerry Brownlee.
No.
The Honourable Nana Mahuta.
Supplementary to the Minister, how does the Minister reconcile his answers with the requirement to engage effectively with iwi, with the Government's expressed support of the Declaration of the Rights of Indigenous Peoples, and why is the Minister ignoring comments of Support Party MP Hone Harawira with regards to deep-sea mining in Northland?
The Honourable Jerry Brownlee.
Mr Speaker, the Government is currently engaged in a very, very constructive dialogue with our support partner, the Maori Party, about the future of the foreshore and seabed. Quite clearly, customary rights and territorial rights are going to be better recognised under the new arrangements than the previous government was prepared to allow.
David Clendon. David Clendon.
Thank you, Mr Speaker. Will the Minister commit to a thorough investigation of Te Aupuri's claim to ownership of the oil in Ranga Basin, and will he commit to reporting back promptly to them the findings of that investigation?
The Honourable Jerry Brownlee.
No.
Question number